for this information session for UC Berkeley faculty, students, and researchers who may be approached by federal agents. Today's presentation is brought to you by Asian Americans Advancing Justice, Asian Law Caucus, Chinese for Affirmative Action, and the Asian American Research Center at UC Berkeley. My name is Annie Lee, and I'm the Managing Director of Policy at Chinese for Affirmative Action. I'd love to allow my fellow panelists to introduce themselves before we begin. I'll pass it off to Hamad.
Thanks so much, Annie, and thanks so much, everyone, for joining us today. My name is Hamad Alam. I'm a staff attorney and program manager here at the Asian Law Caucus, and I lead our National Security and Civil Rights Program, which has been working for over a decade to represent those who have been targeted by the federal government as part of their national security and counterterrorism policies. I'll pass it over to my colleague, Sanjana, for her introduction.
Hi, everyone. My name is Sanjana Potsnis, and I'm a community advocate in the National Security and Civil Rights Program at the Asian Law Caucus. And I will pass it on to my colleague, Adil.
Hello, everyone. My name is Adil Raniwala. I am also a community advocate for the National Security and Civil Rights Program at Asian Law Caucus. I'm very grateful for your time and for returning to the Berkeley campus. I just graduated last August, so it is very nostalgic already, even though it is online. I'll pass it back to Annie for the introduction for AARC.
Thank you so much, Adil, Sanjana, and Hamad, and the entire Asian Law Caucus team. I now want to introduce Dr. Laxiu, who is a professor and chair of the Asian American Research Center.
Thank you, Annie. It's such a privilege to be partnering with community organizations like the Asian Law Caucus and the Chinese for Affirmative Action. The Asian American Research Center at UC Berkeley was launched in 2020. We are a research center that focuses specifically on the study of Asian Americans and Asian diasporas in national, hemispheric, and global contexts. It brings together a vibrant, innovative, and dynamic assemblage of scholars, researchers, policymakers, community organizers, and cultural producers to address a variety of interests and concerns. We also want to raise public awareness of Asian American and diaspora issues, and as well as advance research, supporting curricula, as well as promoting campus community engagements such as this one. So I do want to just say that racial profiling by government agencies is endemic to US society. Racialized communities experience different forms of racial profiling. The recent murder of Tyre Nichols by the police is the latest example of police violence and the institution's continued racial profiling of Black men and the unjust violence against them. The Immigration and Customs Enforcement, otherwise known as ICE, exercises racial profiling of Latinx populations for deportation. Today, we turn our attention to the racial profiling of Asian American scientists at research institutions. This is not a recent phenomenon, nor is it the only kind of racial profiling that Asian Americans have been subjected to. It has, however, intensified in the last few decades. Some of the high-profile cases include Dr. Wenho Lee of Los Alamos Lab, Dr. Sherry Chen of the National Weather Service, Dr. Xiaoxing Shi of Temple University, and Dr. Gang Cheng of MIT. We are really grateful here to have our partners, our community partners here today, who will share their invaluable expertise with us and to help us prepare for any potential unwarranted threats from government agencies. Thank you.
Thank you so much. We'll now begin today's presentation. First, we have a disclaimer. It is important to note that the materials covered in today's presentation is intended only to educate. It is not legal advice. You should not act on the information provided here without seeking professional legal counsel. Neither the transmission nor receipt of any of the materials shared today creates an attorney-client privilege between any of the presenters and any of you audience members. If you need legal assistance, please contact us, and our contact information will be on the last slide. The roadmap for today's presentation will begin with first, the current moment. We want to talk about what is happening at research institutions and specifically what is happening to MEMSA and Chinese academics, faculty, researchers, and grad students. Then we want to situate that in background and context that Dr. Siu has alluded to, because what is happening now is not unique and actually comes from a long history of racial profiling in the United States. I'll pass it off to Hamad then, who will talk about lessons from individual cases and share your rights. And lastly, we will end with a Q&A. Please send your questions through the Q&A function on Zoom, and we will try to answer your questions at the end of today's presentation. The goals for today's presentation are threefold. First, we want to share general information with you so that you all know your rights if you are ever approached by federal agents. We hope that you can use this knowledge and that you can appropriately advise and support other students, faculty, and staff who may be approached by federal government agents. Second, we want to share backgrounds and broader context so that no one further ostracizes any student, faculty, or staff who may be racially profiled by the federal government. And lastly, we hope to empower you with information and connect you with resources, specifically at the Asian Law Caucus and Chinese for Affirmative Action. To begin, this current context and what is happening. So the federal government is racially profiling MEMSA and Chinese academics. MEMSA stands for Arab, Middle Eastern, Muslim, and South Asian. And these academics are being targeted based on their race, ethnicity, or religion, not because of any credible evidence of wrongdoing. The federal government's surveillance and interrogation looks like unannounced visits to a person's home or place of work. It could be requests for interviews with federal agents. And there can also be pretextual immigration appointments, meaning appointments that are supposed to be about your immigration status, but actually are not. And they're actually trying to get information about you and your contacts and your research. And really, they're using the disguise of immigration to lure you into this appointment. This racial profiling fits into a broader background and context of American history, because in every chapter of US history, immigrants and people of color have been scapegoated and painted as threats to the physical safety and economic well-being of the public. Our national leaders have time and time again played into existing narrative frames that consolidate political support and public opinion against the common quote-unquote enemy. Scapegoating, or the act of unfairly blaming one group for societal misfortunes, is a political strategy that unfortunately wins votes by causing animus and harm against marginalized communities. You see this throughout US history, including through the Chinese Exclusion Act of 1882 that barred Chinese laborers because these Chinese laborers were painted as responsible for declining wages. You see this again in the Great Depression in the 1930s, when the American government blamed Mexican Americans for the country's economic troubles and actually deported 500,000 Mexican Americans, half of whom were US citizens. You see this again in World War II, when the government incarcerated over 120,000 Japanese Americans who were allegedly national security threats. The country also has a long history of anti-Black racism, and the Black community has been painted as a domestic security threat in order to try and justify everything from lynchings to COINTELPRO in the 1960s during the Civil Rights Movement. And more recently, Donald Trump's proposed policies, such as a Muslim registry and increased surveillance of mosques, wrongfully cast Muslims as potential terrorists. And when he was elected, he actually codified his scapegoating rhetoric into policy with the signing of the Muslim ban executive order in 2017. I want to take a moment and share this timeline depicting racial profiling of the Asian American community. As you can see, throughout history, Asian Americans have been blamed for public health, national security, and economic crises. And so the racial profiling of MEMSA and Chinese academics is not new. It really comes from this long history. Our community is an easy target because of two pre-existing stereotypes about Asians and Asian Americans. First, there's the yellow peril and dusky peril myths that depict Asia and Asians as a threat to the Western world's existence. Second, There's the perpetual foreigner trope that portrays Asians and Asian Americans as forever outsiders who do not belong in America. These two pre-existing stereotypes make it really easy for us to be blamed when there are public health crises like COVID, when there are national security threats, and when there are economic downturns. We want to highlight two recent examples of racial profiling of Asian Americans. First is the post-9/11 surveillance of MEMSA communities, and second, the China initiative. I'll pass it off to Hamad, who will talk about the post-9/11 security of MEMSA communities.
Yeah, thanks so much, Annie. And again, a pleasure to be with you all. Thank you for taking the time today to be with us. As some examples of racial profiling and government targeting of MEMSA communities, MEMSA standing for, again, Arab, Middle Eastern, Muslim, and South Asian communities. One example is what's called the Interview project that was engaged in by the federal government after 9/11. In fact, a government report itself actually examined what government agency responses were after 9/11 and noted that the Department of Justice in the aftermath of 9/11, 2001, 2002, and continuing for the next several years, initiated a project to interview around 7,600 non-immigrant aliens, and this is a quote, whose characteristics were similar to those of the September 11th hijackers to try to determine what knowledge they had of terrorist and planned terrorist activities. Plainly an example of racial profiling and dragnet surveillance and targeting of entire communities based on similar racial or ethnic or national origin characteristics. Essentially, this is the government admitting that federal agencies plainly engaged in racial profiling, and race, ethnicity, national origin were used as proxies of criminality as they continue to be in broader policing across the country and the national security context in particular. And of course, in the present day, this continues with the MEMSA communities, but has been expanded and continues with respect to Chinese academics, scientists, researchers, and community members under the so-called guise of technology espionage or economic competition. Another example is the Bush administration's National Security Entry-Exit Registration System, or NSEERS in short, which was launched in 2002. This program registered more than 80,000 males, primarily males, over the age of 16, from the age of 16 to around 25 predominantly Arab and or Muslim countries. In fact, most of those countries were actually the precursor to those countries that were listed in the Muslim ban. The Department of Homeland Security deemed these countries, quote, most likely to pose a terrorist threat to the United States. These individuals underwent fingerprinting and interrogations and had to regularly check in with immigration officials, both when entering the country and exiting the country, hence why the phrase entry-exit registration system is in the name. More than 13,000 of them underwent secret hearings that resulted in deportation. And the program, well, admittedly, the DHS actually admitted years later that the program was highly ineffective and in fact found 0 cases of terrorism as a result. And ongoing today to the present day, there are reports from across the country that throughout the 2000s and into the present day, MEMSA and Chinese and East Asian communities have consistently been targeted for questioning by the FBI and other federal agencies without suspicion, with little else connecting them to criminal threats except their ethnic or religious identities. And the Asian Law Caucus continues to represent such clients today. And we'll talk about some of the examples later on in the presentation.
Thank you, Hamad. So I want to talk very quickly about the recent U.S. Department of Justice's China initiative, and then we'll get into some lessons learned from ALC's direct representation of folks who have been interrogated by federal government agents. So as many of you may know, in 2018, the Trump administration launched what was called the China Initiative, which is a federal initiative to investigate scientists of Chinese origin for alleged espionage on behalf of the Chinese government. So since the launch in 2018, the U.S. Department of Justice investigated at least 150 scientists, 90% of whom were Chinese. The subsequent surveillance and arrests destroyed people's careers, reputations, and livelihoods, and in most cases, without any cause. In 2021, there was actually an independent investigation done by the MIT Technology Review, which declared the China Initiative a mess. And they found that the Department of Justice actually had no definition of what constitutes a China Initiative case. Last year in 2022, the Biden administration announced the end to the China Initiative. But while the program has ended in name, the Department of Justice continues to investigate what they call nation-state threats, of which the government of China stands apart. And so there is continued surveillance of Chinese academics and scientists at research institutions in the United States. I do want to note that the national security scapegoating of Chinese academics did not begin or end with the China Initiative. As Dr. Xu mentioned, in the late 1990s, the federal government arrested Dr. Wenho Li, a Taiwanese American scientist. They held him in solitary confinement for 278 days because they accused him of spying for China. At the end of his case, all but one count was dropped due to lack of evidence, and the judge actually apologized to Dr. Li for the government's overly punitive measures. And on this slide here, you'll see a photo of Dr. Xiaoxing Xi, who was a physics professor at Temple University in Philadelphia. He was arrested by FBI in 2015, allegedly for being an economic spy for China. Similarly, the DOJ case fell apart because there was no evidence. And again, this is an example of something that happens before the China Initiative. And even though the formal China Initiative has been disbanded and has been proven to be a disgrace, there's still fallout and underlying suspicion of Chinese academics. In fact, last December 2022, UC San Diego professor Xiang Dangfu was forced out of his position due to an unfounded investigation that began under the China Initiative. While these cases actually fall apart because the government doesn't have any evidence, there is lasting harm to these academics and their families. So first, there is the damage to reputation and career. You're talking about folks who are losing grants, projects, partnerships, jobs, and they're being isolated from their research and academic community. There's huge financial costs related to this because academics are put on leave or they lose their jobs. There are also legal costs associated with hiring attorneys to fight these unfounded cases. There's also the trauma and emotional and mental health tolls to the individual who's been targeted and often the family. So you'll see a photo here of Dr. Xi's family, including his two daughters, and his elder daughter, Joyce, has actually written about the trauma of watching her dad dragged away by the FBI. She recalls how they took him out of the house and wouldn't even let him put his shoes on when they dragged him out. How the FBI agents ransacked their home, and how she was worried about her 12-year-old sister who was watching all of this unfold. These events still haunt Dr. Xi and his whole family. And lastly, there are communal harms. The whole community is treated as a suspect when this happens, just because we share the same race or ethnicity or religion. There's chilled international collaboration because oftentimes scientists here do not want to talk to their counterparts in other countries, for instance, in China. And then there's the exodus of talent from the United States and discouraging others from coming to the US to study or work in the first place. These are long-lasting impacts based on these unfounded racial profiling of MEMSA and Chinese and East Asian academics and scientists. I'll pass it off to Hamad now to talk about lessons from individual cases.
Thanks so much again, Annie. And just a connection to the Xi family on the part of Asian Law Caucus is that Joyce Xi, who you just mentioned, worked with the Asian Law Caucus and specifically on these types of issues to challenge government narratives and targeting of particularly Chinese and East Asian scientists. So that case in particular hits close to home. I'm going to now walk us through a little bit of some of the representations that we've had at the Asian Law Caucus around the types of questioning that we're trying to prepare our communities for. I do want to mention that, of course, we don't want to be alarmist about this. Of course, this is done really just to prepare our communities because we know that historically they have been targeted, and we want to make sure that we're preparing you all with the support that you might need, even outside of formal representation that you may not be able to get in that moment. In these examples, I'll be first, I'm trying to contextualize them because it's helpful to walk through exactly what may have happened in a particular moment, because otherwise it may seem a bit arbitrary. But also I'll be illustrating some of the ways in which rights are exemplified, or moments where you might want to be thinking about exactly how to assert your rights in a certain context. And then we'll be doing a general summary of what those rights are. So to start off, the Asian Law Caucus represented a PhD student at a local university in the Bay Area who is a Chinese national. This representation really came to us after the individual had already been visited by two Department of Homeland Security investigations officers who are distinct from the FBI, but work closely with other agencies in the federal government. This was an unannounced home visit, as the student was just leaving their apartment, familiar scene for all of us, of course, to go to campus. And the DHS officials began immediately asking about the student's research. The student, at that point was not prepared and did not have our representation. And of course, we acknowledge, even for many of us who have been practicing law, this is an intimidating situation. It is a situation where federal agents have their particular badge, their authority that they're exercising, and it may feel like you are compelled to comply to their requests. But one of the things that I want to emphasize in this context is that the student did let them into their apartment. But one thing that I want to emphasize is that there is no obligation to let agents into your home without a warrant. Really, the home is one of the secure bastions in the law that protects you from any sort of government intrusion. And really, agents, except for some exigent circumstances that I won't get into, but I'm happy to answer in a Q&A, the agents really cannot enter your home without a warrant, but certainly they might seek your permission to do so, without which they wouldn't be able to enter. You may refuse entry, and you can note, and this is something that we want to emphasize and we'll emphasize in the rights portion, the know your rights portion, is that you would like to speak with them only with an attorney present, and that is your right to be able to have an attorney present during that questioning. And then another point that we want to make sure we raise is ask for business cards or identifications. It's your right to do so. Of course, they may answer with something like, I don't have my business card, but nonetheless, you can still write down their names. And that might be relevant and helpful for any attorney you might actually approach after the meeting that you had with the encounter that you had with the agents. There was then a request for a follow-up interview at a local cafe. Again, there is no obligation to attend such requested meetings. Really, absent a court order, there's really no obligation on the part of a private citizen to comply with such a request by a federal agent, as much as it may seem daunting. And in this case, if there is such a request, this is where we really emphasize contacting an attorney so that they can advise you of your rights and the next path to take. Soon after, the DHS agents sent by mail what's called a call-in letter. A call-in letter is essentially a letter that does exactly that, where the DHS and the agents are requesting that you come in, and they're calling you in to their office to show up in person to discuss a certain topic that they're highlighting in that letter. In this case, it was, quote unquote, a visa audit, which by the plain language of those terms, we can see that would mean some examination of the visa that the student was on, or compliance with the visa's requirements. However, from our experience, we know that such call-in letters really are not typically focused on the topic that is expressly identified in the call-in letter itself. We typically understand that this is a way to get the individual who is being subject to the questioning to come in, to meet with the agents and to answer some questions that may or may not even be related to the topic that's identified, in this case, the visa. And in fact, in this case, I personally represented this individual in San Francisco and accompanied them to meet with the federal agents. And I found that as predicted, the questions were in fact not related to the visa, but were in fact related to the individual's research, both here at the university that they were in, as well as their contacts and any research they had conducted in the past in China, where they had undertaken study before they came to the United States. In this case, we would really advise that you consult an immigration attorney as well as an attorney working on these types of issues like we have here at Asian Law Caucus, and especially if you intend to meet with agents. In many cases, it's a case-by-case basis. Sometimes we will advise that the attorneys can simply have a phone interaction with the agents themselves without getting the clients involved. And that's really what the attorney is trying to do, to make sure that we create a barrier between subjects and the agents. But at the very least, there should be some consultation with an attorney. As I mentioned, the HSI interview itself did not relate to the visa audit. There were impressions given by the agents that this is routine, when in fact, oftentimes, as Annie mentioned, it's actually targeted, and it's based on the individual's racial, ethnic, or national origin. And in reality, what I found to be quite humorous actually in that moment was that the agents did not have any strong grasp of research, and the three of us who were not engaged in any scientific research, myself and the two agents, really frankly had no clue what was being talked about by the individual being subject to the questioning, our client. So really gives you the understanding that oftentimes in our experience, agents and federal agencies are really engaging in a fishing expedition, essentially, to try and uncover as much information as they can that can be voluntarily given. And that's where having an attorney helps, to be able to sift through exactly what should be responded to and what does not need to be responded to. Really, just rounding this out, agents often use their authority to compel information from those who really have no obligation. And that's what we want to emphasize, that you have no obligation to speak to them. And a legal representation can be really critical. An attorney can object to the improper questioning and help you prepare. And in our experience, again, once an attorney does begin to represent in these types of cases, oftentimes, not always, of course, but oftentimes, the agents will actually relent, and they will really make no further contact, as was the case in the case of this particular representation. So moving on to an example now of actually a US citizen. So we want to be able to cover the various different statuses as much as we can. We've represented in the past a US citizen of Afghan heritage from around the Bay Area, who is married. A critical piece of information is married to an Afghan national who is seeking to become a citizen. This US citizen of Afghan origin was approached outside his home while he was washing his car. And what was interesting is that the agents immediately began talking to him about the particular car that he was washing. It's often a tactic that is used to sort of disarm an individual, to make them seem like the agents are actually being friendly. And in some senses, it did make our client a bit more comfortable to engage in conversation with them, because he likes cars, and that's what he wanted. He likes talking about. What we want to identify is that in this particular case, the agents were coming from the FBI's Joint Terrorism Task Force. So identifying all these names can be really helpful, especially for attorneys who would be able to then make contact on your behalf. And thankfully, this client was able to get a business card. The officers mentioned the client's Afghan national wife who had already applied for naturalization at that time. And what they hinted at was that they could either help or by implication hurt the application if in fact he does or does not talk to them. So, again, making note that officers do often leverage facts they know about the individual to get more information from you. In this case, it might be someone, a spouse that you're applying for naturalization for, in order to get more information, again, realizing that you're not compelled to do so, but certainly in that situation, they can create that situation where you feel you might be obligated. And the last example that we want to raise is a Silicon Valley professional, again, a US citizen of Muslim and South Asian origin, over a decade of experience in working in Silicon Valley at a tech company, really a consummate professional with a great educational background, who was approached by both FBI agents and local law enforcement as part of the JTTF. So if you remember, the JTTF is the Joint Terrorism Task Force that I just mentioned in the last example. In the last example with the Afghan US citizen, he was actually just approached by only an FBI officer. In this case, I want to distinguish and say that oftentimes local law enforcement can also be involved. And when they're working with FBI agents, they actually have a bit more authority to act than local law enforcement do generally. He was approached outside his place of work. So this is distinct, of course, from being approached outside of one's home, and questioned about his connections and travel to South Asia, as well as his religious and political opinions. So one thing that we want to mention is, if you're approached outside your place of work, even if you're not at your home, that doesn't matter. You are still free to decline questioning. So if you're approached on campus, if you're approached at work, the home itself, they cannot enter again without absent a warrant. But in terms of the question of whether you have to answer or are obligated to comply with responding to their questions and engaging in conversation, that applies in every context, where you can feel free to decline and mention again that you would like to speak to them only with a lawyer present. And generally, we advise not to speak with agents or law enforcement without representation. But we want you to remember at the outset, because the initial contact, if it does ever happen to you or to anyone else, we want you to remember that questions around religious beliefs or political opinions are inappropriate for government authorities to ask. Now here, of course, the baseline is to maintain your silence. But if they do ask about religious beliefs or political opinions, take note. That may be very relevant for an attorney to know in the future. The client was confused because at least one of the officials was a local police officer. We want to mention that generally all of these rights and the Know Your Rights that we'll be presenting shortly apply to all law enforcement officials, federal or local. And generally speaking, and I think particularly to those on campus, faculty, and those in positions of providing resources, always advise students and faculty to consult and or obtain legal counsel if they do meet with agents. This can be really critical, and in fact can really shorten the amount of time and the interactions that might be taking place, given our experience that we've had with such representations. We also want to note that you do not want to invite agents to campus. That is giving them sort of free reign and free access. And generally speaking, I think being in touch with attorneys around such requests by federal agencies around these issues is probably the prudent thing to do. Contact Asian Law Caucus and Chinese for Affirmative Action as early as possible. If such incidents happen, that can be really, really important. And keep in mind the broader context of these investigations and the broader sort of political context, as mentioned by Annie in the present moment. So we'll quickly just wrap up with your rights, a summary of what your rights are with law enforcement, including the FBI and DHS, as we mentioned, are two federal agencies that engage in such targeting of communities. So the very first thing is you have the right to remain silent. And one thing that I actually want us to all pause here and just mention, again, this can be really intimidating when federal agents approach you. And saying something like, I have the right to remain silent to a federal official is difficult. But I think one of the ways in which you can assert that is by affirmatively stating once you've identified that there are federal agents trying to have a conversation with you, affirmatively stating that I would like to have my lawyer present. So I'm going to pause real quick, and let's just take about 10 seconds to practice this. So in your space, I know you all can't unmute yourself, but just in your space, wherever you are, if you can say it, whisper it to yourself or say it out loud. If we can all practice, we're going to say, I wish to have a lawyer present. Just simple, those words. So at the count of three, at 3, 2, 1, we'll practice that. 3, 2, 1. I wish to have my lawyer present. We'll do it again. There you go. And I'll do it again. 3, 2, 1. I wish to have my lawyer present. There you go. And that's, practice that at home. Again, I know that's very intimidating. I can tell you that when I first started my career about 9 years ago, around that time, there was an incident that happened in Chattanooga, Tennessee. Now, believe it or not, I, as a Pakistani American, have family in Chattanooga, Tennessee. And one of my aunts was engaged in her community where a particular individual who was being targeted by the FBI came from. And the FBI had given them a call to sort of ask, hey, can we talk to you? Can we visit you? When she called me, I remember telling her, giving her this advice, and she began crying. So I want to mention that I know how difficult that is. I look at my clients and I just really marvel at their courage to be able to navigate these issues when they do. And I, as a lawyer, I wish for no one to go through this. But in the case that it does, we want to mention to you that we have your back, and we want to mention to you that really practicing that courage and saying, I wish to have my lawyer present is really effective and really, I think, begins to put the agents on the back foot because they realize that you know what you're talking about and you know what your rights are. Really importantly, tell the truth or remain silent. Making false statements can be a felony. And this is why, as lawyers, we really advise you to remain as silent as possible. Oftentimes, we do hear things like from the community, which is understandable and it's true, that, well, I have nothing to hide. I've done nothing wrong. So why would I want to remain silent? I can just sort of talk it away. And, while we certainly believe you and we believe that you will absolutely have nothing to hide, the reality is that we don't quite believe the federal government. And in our experience, oftentimes, even any sort of slight misremembrance in the facts can be taken advantage of. And we want to make sure that you're protected as much as possible. So asserting your right to remain silent and getting legal representation or advice and counsel is very, very important at the outset. With respect to cell phones and other devices, this is actually quite clear Supreme Court law. And we're very happy that it is quite clear in this space because the Fourth Amendment, unfortunately, is very muddled on this. But when it comes to cell phones or other devices, law enforcement cannot search your cell phone or other devices without a warrant or unless you give them permission. Now, of course, again, they're going to try and get your permission in that moment if they don't have a warrant. They're going to try to use their authority. They're trying to use some persuasive tactics and perhaps intimidation. But your right is that if absent a warrant, and if they do have a warrant, by the way, you should examine the warrant. The warrant has to state very clearly what they're searching and what they're searching for. If it doesn't include that, you can object to the warrant. Now, however, if the agent still attempts to examine your device, now for very obvious reasons related to, of course, the use of police violence and excessive force, you should not resist. But you should state affirmatively that you do not consent to the search of your device. And affirmatively stating that and relaying that to any lawyer afterwards that might be representing you can be very helpful for that particular lawyer to know. You should ask the officer, am I free to leave? If the officer says yes, tell them you are going to walk away. Affirmatively communicate with them. Tell them, I'm going to walk away. And then calmly do so with your arms and hands visible. You don't have to have them sort of raised up, but you should really sort of keep them clear and visible so that the officers know that you're not a threat to them or making any sudden movements. And this is really primarily for your safety. Do not argue or run away. Again, even if you believe what is happening is wrong, there have been too many incidents of police violence with misunderstandings or misperceptions around what is actually happening, or even the slightest sudden movement being justified for violence. And so we want to make sure that you're staying safe. And the thing that I'll lastly mention here is, if you have a pending immigration application, please also consult an immigration lawyer or raise that with the lawyer that you're talking to. So for instance, if you call us, tell us that, hey, I actually have a pending immigration application, and we'll make sure to have an immigration lawyer consult with us in your representation. I wanted to have a dedicated slide when it comes to law enforcement interactions in our homes. As I mentioned, the home is a context where really it's sort of the sacred bastion in the law when it comes to your rights and your protections. No, officers really cannot enter your home without a warrant or some exigent circumstances, like they believe some sort of crime is imminently happening and there's some imminent harm that might take place. Absent those exigent circumstances, they really cannot enter. So if police knock and ask to enter, do not allow them to enter or search your home unless they have a warrant, and ask them. Say, well, do you have a warrant? And if they say, yes, they do, again, examine that warrant and determine, is it correct? Does it actually identify your address? Does it actually identify what they're actually searching for? You may speak to them through a closed door. And if you do not fear arrest, you can step outside and close the door when talking with them. But our general advice is you can simply communicate with them through a closed door. And this is not something that is improper. Really, again, just getting into the specifics of the warrant, it must be signed by a judge. You have every right to ask to see it and to examine it, and to check the address and the scope of the area to be searched. However, you do want to make sure, if you're on probation or parole, there might be certain search conditions that you are subject to. So you want to make sure you're actually clarifying that beforehand. And if you then object, then there may be a problem may be posed. And so you want to be aware of your own status. And then lastly, do not physically resist officers seeking to enter your home, even if they don't meet this criteria. Just simply affirmatively state that you do not consent, but allow them to continue what they're doing. Oftentimes what ends up happening is that this can be very important if for a lawyer to know who's representing you, to know later on that, look, my client objected, even though the search was not warranted and was not proper. Lastly, when it comes to immigration status, again, even if you are here as a visa holder, as a green card holder, and you're not a US citizen, you still have the right to remain silent. The Constitution applies to you in this country. It's not as if there's a subset of people where the law doesn't, or the protections provided by our Constitution or civil rights laws do not apply. You do not have to discuss your citizenship with police or citizenship status with police or immigration agents or any other officials. However, you are required to present your green card to an immigration officer if they request, and this is actually required by statute. Do not lie about your immigration status or provide false documents. Of course, that goes without saying, but really making sure that you're providing accurate information when it comes to those requests. But again, all other questions you really do not have to answer. I will say just one thing, and this is a little bit outside the scope, but entering the country, green card holders in general, you do not have to answer questions, because unless there's been some really lengthy stay outside the country, past 6 months, you have a right to enter the country. However, refusing to answer questions in that context could delay your entry. So we always advise getting in touch with an immigration lawyer before you travel abroad, especially for a lengthy amount of time, perhaps about 4 to 6 months, and certainly if it's over 6 months, because that can be really important to know your rights and what you can and cannot be asked about, and what you should be talking, what you should be answering when re-entering the country. Lastly, I'm really excited to share that we along with Chinese for Affirmative Action, were able to create some Know Your Rights materials in both simplified and traditional Chinese. These are available, and we'll be sending the links shortly over the chat where they're housed in PDF form if anybody would like to review them in digital form. But these are Know Your Rights materials. Physical copies will also be available in the AARC office space as well on campus, and so you can pick them up. Of course, these are available in English, and the reverse side is in English on both of these, but we want to make sure that we're also providing them in language as well. So to the extent that they're helpful for you, or they're helpful for your loved ones or others you know, please do send those links and disseminate them across your networks.
Excellent. We are at questions. I'm going to let Hamad take a break and look at some of the questions that have come in. I am able to answer some of them, so I will take those on now. There is a question about the trend of harmful discrimination and accusations against Chinese professionals beginning before the China Initiative. And the question is, how the China Initiative traces back to Obama's pivot to Asia, which has been receiving bipartisan support throughout several presidential administrations and has become acutely dangerous. So as you can see from the history, that this is happening under Democratic and Republican administrations. And while it flares up and down based on what's happening in global events like 9/11 obviously resulted in a spike that was very targeted towards MEMSA communities. With the rise of China in the last 3 decades, it has become increasingly, the focus of the government has become increasingly lasered on China and its rise. And there are externalities for Chinese Americans and people who look like Chinese people, quite frankly. And so you see that with, there's this new House committee that's about, it's supposed to be about strategic relationships and competition with the CCP, but we all know that that actually just bleeds out and targets just Chinese people and Chinese professionals. You see this in Texas with these new 2 Texas bills that are forbidding not just Chinese corporations, but Chinese nationals from owning land. And so that's why we're very focused on political rhetoric, because it bleeds out. And it is not limited to CCP or Chinese corporations, but actually any Chinese people. And so with the rise of China increasing, we fear that this will continue, even if the official China Initiative is over. There's another question about any advice for children and adolescents. So in California, law enforcement can talk to children without parents, but it has to be voluntary. So I would coach your children, little children, adolescents, teens, to say, I would like to wait for my parent to come. I have a child who is 2, and he is biracial, Chinese and Black. And when he is old enough, I would say 4 or 5 years old, I will coach him to practice these phrases. Am I free to leave? I would like to have my mother present. Do you have a warrant? I do not consent to the search of this device. It is very, very important to teach your children, including your teens, to say this, because it is scary when you have a police officer, an FBI agent, but do not only say those words. Do not say anything else. Do not answer any questions, even if the questions seem innocuous, because they will use that against you. So only say these practice terms. Am I free to leave? I would like my lawyer present, or I would like my parents present. Do you have a warrant? I do not consent. And they can just sit there and wait for you to come as their parents. That would be my advice. I'll pass it off to Hamad now, because I think there's some specific questions that he can take on.
Yeah, thanks so much, Annie, and appreciate so much and co-sign that advice. A fundamental question that I should have clarified is being asked around, are attorneys at ALC free of charge if one needs a consultation or even representation? So I should have clarified. Yes, Asian Law Caucus is a free legal services organization, and in fact, our National Security and Civil Rights Program does not actually examine income level when it comes to representations on these issues, precisely because these issues are so specialized, and really it's the whole might of the federal government, and so we want to make sure that we're providing representation to any community member who is targeted by these issues. In terms of a consultation and a representation, they're all free of charge, but of course we would first need to examine the case and examine the facts, and without forming an attorney-client relationship, and have a consultation before we would actually determine if we can represent any individual who is being targeted. Another question is around, could you share more about the process of finding an attorney? So on this slide, you have our contact. If something like this ever does happen to you or a loved one, it's really important to make sure that you get in touch with us. And of course, if we're not able to represent, we certainly have resources available where we can try to refer you to another attorney or another organization. Sometimes it might be that it might be a more complex case requiring private bar attorneys, and we'll certainly try to make sure that we're working with them for a more low bono cost, of course, but we're happy to sort of talk more about what that representation could look like. There's a question around, are we allowed to take photos, videos, and how do we show that we're justified to refuse? So yes, you are allowed to take videos in certain instances, but really we would advise determining whether or not it's safe, it feels safe to do so in that moment. Oftentimes, that can lead to more sort of a more hostile encounter with agents, more hostility on their part, and really might encumber your ability to be able to assert your rights and to be able to end the interaction as much as quickly as possible. I think what is completely permissible, of course, is to really relay what happened as soon as possible to an attorney or an organization as soon as the event happens. And really, again, all of the things that Annie mentioned, asserting your right to representation and saying, I wish to have a lawyer present, I do not consent to the search if there's no warrant, and really making sure that you're asserting affirmatively your rights and your refusal to consent. How do we show that we're justified to refuse? Really, I mean, the words are enough in that moment. I wouldn't advise trying to get into a sort of an argument or discussion around a dialectical sort of discussion with the agents. I think that would not be very productive. You just want to be able to be prepared with knowledge of what your rights are and affirmatively state them. But as we mentioned, if the agents insist and persist with examining your device or examining or searching your home, even if you feel that they're not justified to do so, affirmatively state that you do not consent to the search, but allow them to do so still, and do not resist. What would a warrant look like? That's a great question. Really, you can find this online. It's typically issued by a federal court, and you can really just Google it. But I think maybe we can follow up with an example. I think we might actually have some examples. We might have to redact some information. And yes, you can certainly take a photo of it. But again, just being mindful of how that interaction is looking like. Sometimes, I mean, in our experience, agents have been of all sorts of stripes. Some of them have actually come off very friendly and very nice, even during a search, and have allowed family members to just sort of sit and said, hey, like, do you want some water? I mean, we've even had things like that. But other times it's a very hostile position, and as we mentioned with Professor Shi's example, but you can certainly find examples of such warrants online. And then there was a final question around, do individual rights in these cases vary between US citizens, permanent residents, and others? So as I mentioned, as a blanket sort of statement, a broad statement. The Constitution and civil rights laws apply to anyone who is present in the country, regardless of their status. They do not have to be necessarily U.S. citizens or green card holders. The laws apply, the protections apply. However, there is a distinction to be made, as I mentioned, when it comes to particularly border reentry, depending on your status. If you're a U.S. citizen, you have a prima facie right to be able to enter the country as soon as you show evidence of your U.S. passport. Really, you don't even have to answer any questions. It could delay your entry, but there is a assumption that you should be allowed to enter. Same with permanent residents, in the sense that as long as you haven't sort of violated any particular conditions, namely breaking laws abroad or being abroad for more than 6 months, which is a longer stay than is contemplated for green card holders, because the purpose, of course, is to establish residency in the United States and to show that you are doing so. Again, you have an assumption of admittance if those conditions are met, but delaying answering or not answering questions really can delay your entry and can cause some problems that we would not advise. And again, we would advise in that case, really talking to an immigration lawyer before you travel. That's all the questions that I have on my end.
Well, I just want to thank everyone so much for participating in our Know Your Rights presentation today. I hope you are walking away from today's presentation understanding that you do have rights and you are allowed to exercise them, and that you've got our contact information. So please follow up with us if you have any questions. Please use the links in the chat to find materials about your rights, and you can keep those with you. And I don't know if my fellow panelists have any other closing words. I will pass it off to you if you do.
I just want to mention a special note of thanks, Dr. Su and AARC. Thank you so much for partnering with us and the Berkeley community, and CAA. Thank you so much for your partnership on this. Dr. Su, I'll hand it off to you.
Thank you both, all of you, so much for this wonderful presentation. Very informative and incredibly, just encouraging in terms of what we can do, to protect ourselves. The video is being recorded and it will be available for others who want to watch this after this event. So it will be available on the AARC website. So I just want to let people know. Thank you so much.
Thank you, everyone.